to The Next Fight. I'm Don West, National Trial Counsel for CCW Safe. Today we'll continue with our discussion of the various stages of a jury trial. Today, opening statements. An opening statement is sometimes compared to a roadmap of the case. It's the opportunity for the lawyers to tell the jury about the evidence they expect to present and to outline the testimony of the important witnesses. Judges will usually permit some limited discussion of the law to give the jury a frame of reference. However, an opening statement is not an opportunity to argue the points, but primarily to give the jury a heads up on what the case is about. Certainly, the lawyers can talk about specific witnesses and point to certain testimony as being important to the main issues of the case. The prosecutor has to prove every element of each charge, so their opening might be pretty broad in scope, whereas the defense might be relying on a certain aspect of the evidence and might not care too much about most of the evidence. For example, in a fatal self-defense shooting case where the prosecutor has charged the defendant with murder, the prosecutor will have to prove that the defendant shot and killed the victim and did it with premeditation or out of spite and hatred. The defense will probably concede that the defendant killed the victim and will admit that he shot him on purpose. In fact, the defendant probably told the police right from the beginning that he's the person who shot the victim, but that he did it in self-defense. As a result, his lawyer's opening may be fairly limited and focus on pointing out the evidence that shows that the defendant had the right to use deadly force because the victim had attacked him and he had no choice but to defend himself. Most opening statements are fairly short, and on occasion the defense will reserve the opening until after the prosecution has rested the case. I personally don't prefer that approach, especially in self-defense cases. When I have a case with an affirmative defense, and self-defense is an affirmative defense, I want the jury to know right from the beginning that we contest the evidence and that my client was justified in doing what he did. I don't want the prosecution case to settle in before the jury hears from us. While the opening statements aren't considered evidence, a good and powerful opening can get the jury questioning the prosecution evidence right away and guide them what to look for in the prosecution's case that in fact supports the defendant's self-defense claim. Thanks for listening. I'm Don West for The Next Fight.